and a striking moment of concern for the victims. Sunrise host Matt Shirvington has shared poignant thoughts about the recent developments regarding Erin Patterson's case, particularly following the announcement that the Crown intends to contest her 33-year prison sentence for murder. This legal move has captured significant public interest, as it involves one of Australia's most notorious criminal cases. The Office of Public Prosecutions has formally submitted an appeal to the Court of Appeal, arguing that a more severe punishment is warranted for Patterson, who was convicted for orchestrating a deadly mushroom meal that resulted in the tragic deaths of Don Patterson, Gail Patterson, and Heather Wilkinson, while nearly taking the life of Ian Wilkinson as well. Despite the gravity of her crimes, it's critical to note that Patterson will be eligible for parole once she has served 33 years, a point that many find contentious. This situation is set to unfold with two distinct appeals at play, one initiated by the Crown, seeking to impose a stricter sentence, and another from Patterson's legal defense, which aims to challenge her conviction. These dual appeals promise to keep this high-profile case in the news for the foreseeable future. During a recent segment on Sunrise, Shirvington reflected deeply on the impact on the victims' families, stating, "I can't help but think of the relatives left to grapple with the aftermath of such a horrifying event. Just imagining them enduring another 28 days of uncertainty as the appeals process plays out is simply heartbreaking." In a conversation with criminologist Xanthi Mallet, Shirvington sought to uncover the implications of the Crown's decision to appeal. Mallet noted a growing trend since about 2018, where the Crown has increasingly sought to challenge sentences that it deems insufficient in conveying the seriousness of crimes committed. Shirvington further probed what the term manifestly inadequate signifies in the context of the Crown's appeal. Mallet clarified that this phrase suggests either that the imposed sentence fails to adequately mirror the gravity of the offense or does not sufficiently deter potential offenders from committing similar crimes in the future. Given that this case involves 3 murder charges plus an attempted murder charge, the Crown believes that the 33-year minimum sentence does not appropriately reflect the severity of Patterson's actions. During the sentencing process, prosecutors argued passionately that Patterson should not qualify for parole and advocated for a lengthier imprisonment than that which was ultimately decreed by the judge. In contrast, Patterson's defense team has not yet disclosed the specific reasons for their appeal, leaving many to speculate about their strategy. According to the legal framework in Victoria, both parties in a criminal case are granted a period of 28 days following a sentence to file an appeal with the Court of Appeal. There are provisions for extensions, allowing the process to potentially extend beyond this initial timeframe. Shirvington inquired about the procedures that would take effect after the 28-day period concludes. Mallet explained, "Once those 28 days elapse, which start from today, a solitary judge from the appeal court will evaluate whether to grant permission for those appeals to proceed. Both sides will present their respective arguments and statements for the judge's consideration in this crucial determination." Reporting by AAP. What are your thoughts on the potential for a more severe sentence? Should the Crown's appeal be a standard practice in such high-profile cases? Let us know in the comments below.